Donald Trump, Maga, his supporters and allies are all over the country trying to steal this election. We got less than 3 weeks before we go to the polls and hopefully elect Kamala Harris in a landslide. But trust me, Trump is cheating left and right on every hand. In fact, I brought you a story out of Georgia last month, and there has been some updates to that story that I want to share with you today. And again, it shows just how much Trump is behind the scenes cheating, just how desperate he is. The man is totally desperate. So we're going to get into this story. Stay with me until the end. Now, before we get into it, please go over to Amazon.com and grab a copy of my book, Education and Justice, How Public Schools Fail African American Males. If you have an African American male child in school, you really need this book because it tells you the many ways that the public school system mistreats our sons and what we can do to help them. So go over there and get your copy. All right, so I don't know if you remember these people, these 3 Republicans. These folks are on the Georgia Board of Election, and they were appointed to that board in September, I think it was, maybe August, I can't remember the exact month. But they promulgated some rules and regulations that were intended to give Donald Trump an edge up in the state of Georgia. And of course, Georgia is a very critical battleground state. So there's a lot of focus in the state of Georgia. And so when these 3 Republicans were given a seat on the Georgia Board of Elections, everyone knew that it would spell trouble for Kamala Harris. All right, so again, they got up there and they promulgated about 8 different rules over a span of time. Well, this judge, Judge Thomas Cox, he found that those rules are unconstitutional, and he struck them down. Good for him, Judge Thomas Cox. He wanted to make sure that MAGA understood that what they had done by promulgating these rules were, in fact, against the law. All right, so we're going to go over there and look at the judge's opinion. Again, I really enjoyed reading it. I am an attorney, so I love reading court opinions and court documents and books on the law and so on. I just love it. That's a favorite pastime of mine. I sort of geek out. All right, so let's read a little bit of this. I think you'll find it fascinating as well. All right, so this is the judge's order, an order granting declaratory and injunctive relief. Declaratory relief means the judge declared something that the plaintiffs wanted. And injunctive relief means the judge enjoined or stopped something that the plaintiffs wanted. All right, so let's look at what I have highlighted here. It says, the substantive facts in this case are undisputed. In September 2024, the State Election Board promulgated a number of rules challenged by the plaintiffs. In particular, plaintiffs challenge SEB, State Election Board rules, and there are 8 different rules there. All right, the judge says the 2024 election is to take place on November 5th, 2024, and early voting started on October 15th, 2024. So it stood out to the judge, it stood out to me, stood out to everybody how close to early voting and to regular voting these rules were promulgated by these 3 Republicans. I mean, they did it intentionally just before the election so that it would be difficult to try to stop them. But the judge stopped them nonetheless. All right, now let's fast forward to some other areas that I have highlighted. So this says all rules enacted by the SEB must be consistent with the existing election code in the Georgia Constitution. So the judge starts out by saying that the rules must be consistent and in compliance with Georgia election code or Georgia election law and the Georgia Constitution. And I would add the U.S. Constitution. All right, so he found that the rules were not consistent with the Georgia election code, nor the Georgia Constitution, nor the U.S. Constitution. And here's some of his rationale. All right, so OCGA section 21-2-493 sets forth the certification procedures and requirements that superintendents must adhere to when certifying election returns. All right, so this is a very, very important rule because the election results must be certified. And this three Republican group here, they promulgated a rule that affected the certifying process. All right. So it says here the rule, SEB Rule 183-1-12-.02 provides that to certify election returns. Now watch this. A superintendent must attest after reasonable inquiry that the tabulation and canvassing of the election are complete and accurate and that the results are a true and accurate accounting of all votes cast in that election. The reasonable inquiry provision of this rule is not part of, so the judge is saying here, the reasonable inquiry provision of this rule is not consistent with OCGA section 21-2-493, which is the Georgia Election Code. All right. And it adds additional and undefined step into the certification process. As such, it is inconsistent with and unsupported by OCGA section 21-2-493. All right. And thus, it is void and unenforceable. So the judge says here, and it's really important because the rule was really messed up from the beginning. The rule essentially said that some election worker could have a reasonable amount of time to look at the Georgia election results before certifying those results. Now, what a reasonable inquiry meant, exactly what that meant, no one knows. That could be overnight, that could be 5 days, that could be 2 weeks, that could be 2 months, that could be a year. In other words, this was added to prevent the certification of Georgia's election results. That was the only reason why this was added. And it added a provision that is inconsistent with Georgia election law. And that's what the judge said in the beginning of this opinion. The rules must be consistent with the Georgia election law because the state election board does not supersede, its authority does not supersede Georgia legislature who have already enacted and determined what Georgia election law is, and they did not include some reasonable inquiry provision. So the judge said, because this is inconsistent with Georgia law, it is void and it is unenforceable. All right? Good for the judge because, look, man, can you not see mayhem coming out of that rule? Can you not see come November 5th, there's no way the Georgia election would have been finalized and any Republican MAGA member could have wreaked havoc and just played tricks on Trump's behalf, right? And that's what Trump wanted. That's what he wanted. He wanted exactly that. He wanted there to be mayhem and chaos, and he wanted MAGA in Georgia to have the ability to stop the certifying process. Does that sound familiar? That is precisely what he was trying to accomplish on January 6, 2021. All right. Trump was so happy with these three that he shouted them out at one of his rallies. Let me show you.
I don't know if you've heard, but the Georgia State Election Board is in a very positive way. This is a very positive thing, Marjorie. They're on fire. They're doing a great job. 3 members, Janice Johnson, Rick Jeffries, and Janelle King, 3 people, are all pit bulls fighting for honesty, transparency, and victory. They're fighting.
Yeah, he was happy about that. He shouted them out, called them pit bulls, called them by their names. Okay, so he was really, really, really happy. Well, his happiness did not last very long because Judge Thomas Cox invalidated those rules. Now, his opinion has already been appealed by the state Republican Party as well as the National Republican Party. RNC and Georgia's Republicans have already appealed the judge's decision. I think it was Thursday, they filed the appeal. But nonetheless, as of right now, those rules cannot be enforced. So the state Supreme Court, the Georgia Supreme Court, will decide if those rules can be enforced between now and the election. But I want to go back to the judge's opinion because it is very interesting, some of the things that he said here. I mean, he walked through all 8 of these rules and found every one of them violated Georgia law, Georgia Constitution, and the U.S. Constitution. And I want you to see this because before I go on, this is really important. Let me explain something. This is voter suppression. Any sort of way that someone passes any sort of law that or promulgates some rule that interferes with someone's ability to vote, even if the reason for it they claim is voter integrity. There's no voter integrity giving local election officials the opportunity to hold up the certification process for weeks or even months or never. I mean, that's voter suppression. And it reminds me of something Byron Donalds argued at his most recent Breakfast Club appearance, his interview. He argued that the pre-clearance rule that was gutted from the Voting Rights Act is no longer needed. But this is precisely why it is needed. Because had it been in place when these 3 MAGA members tried to pass these rules, they would have had to have gotten pre-clearance or pre-approval from the Justice Department. Now they don't have to do that, so they can just pass these rules. They can change their voting laws. And that's what Georgia has done to favor Republicans. So we absolutely need pre-clearance. We absolutely need the Voting Rights Act fixed and corrected. All right? Byron Donalds was pushing, as he always does, disinformation. All right, here's another rule. We're not going to go through all of them, but here's another one. SCB Rule 183-1-14-02 requires that a person delivering an absentee ballot provide a signature and photo ID at the time the absentee ballot is delivered. So when a person in Georgia under this rule drop off an absentee ballot, they had to show signature and photo ID at the time the absentee ballot is delivered. The problem with that rule is the Georgia legislature did not enact or include that provision in its election code. And that's what the judge points out. The judge says OCGA section 21-2-385A provides that absentee ballots may be mailed or hand-delivered by a voter's mother, father, grandparent, uncle, aunt, brother, sister, spouse, son, daughter, niece, nephew, grandchild, son-in-law, daughter-in-law, mother-in-law, father-in-law, brother-in-law, sister-in-law, or an individual residing in the household of such elector. They didn't include anything about signature and voter ID. The judge goes on to say, additionally, this provision allows a caregiver of any disabled elector to mail or deliver that elector's ballot. Neither statute requires presentment of a signature or photo ID by the authorized person delivering the ballot. So the person bringing the family member's absentee ballot does not have to bring along the person's photo ID and the person's signature. The Georgia legislature, even when they changed a lot of their voting laws, they still did not include that provision. And remember, the judge said up front that these rules got to be consistent with Georgia law. And because that rule is not in Georgia's law, that rule cannot be enforced. All right? That's what the judge said. All right, here's another one. SCB Rule 183-1-14 demands video surveillance and recording of authorized drop boxes after the polls close. The rule further provides for the removal and closure of any drop boxes not so monitored. But the judge says OCGA section 21-2-382 provides for certain monitoring of drop box locations. However, it does not require video monitoring, and it does not allow for the removal or closure of authorized drop boxes that are not video monitored. So he says the rule is inconsistent with the law. The law prevails, and he strikes down the rule. You see, all of that comes from Donald Trump's big lie about there being massive voter fraud. And it's not true. The election was not stolen from Donald Trump. All right, that's a lie. Went through many court systems, many judges, including GOP judges, judges even that Trump appointed, and all of them said that that was a big lie. Okay? Nevertheless, they tried to pull this hanky-panky in the state of Georgia. And then this one here is really cumbersome. SEB 183-1-12-.12 requires poll managers and poll officers to engage in a cumbersome process of ballot hand counting. After the close of polls on Election Day and prior to the transmitting the ballots to the superintendent for certification, this hand counting exercise is nowhere authorized by the General Assembly in the election code. The judge says the legislature did not authorize hand counting anywhere in Georgia election law. And therefore, he said it was void and unenforceable. So can you imagine the mayhem? We saw that in 2000 with what was it, the Bush v. Gore election, where there were literally hand counting ballots and checking the hanging chads and all of that mayhem. Do you remember that? So thankfully, this judge had the courage and the insight and the foresight and the knowledge and experience of Georgia law to know that this stuff is just all created to cause mayhem in a very important battleground state. Essentially, these rules were put in place to stop the certification of Georgia's election results if Trump lost. That's all these rules were about, and the judge saw right through it. Okay? So I want you to see something else here. The judge, in bold caps, says, the court here declares that these rules are illegal, unconstitutional, and void. He wanted it clear. I mean, he put it in bold lettering, all caps, that these rules are illegal, unconstitutional, and void. And then he enjoins, he stopped the state from enforcing the rules, again with language that is all caps and bold. He says, the court hereby enjoins, that simply means stops, the state of Georgia and the SEB from enforcing, requiring compliance with, or otherwise utilizing SEB rules, and he names those rules out. Additionally, and this is sort of the conclusion of the matter, and again, his conclusion are in bold cap letters. Additionally, the state and the SEB are hereby directed to immediately remove these rules from their roles in official reporting and to immediately inform all state and local election officials that these rules are void and are not to be followed through the same mechanisms that the SEB provided such rules to the state or local election officials, or through the same mechanisms that they inform the state or local election officials of these rules. So that is the conclusion of the matter on the Superior Court level. Now, the appellate courts that are right over the Superior Court judges in Georgia would ordinarily hear the appeal, but this appeal went straight to, Maga's appeal went straight to the Georgia Supreme Court. And so the Georgia Supreme Court has what? less than 3 weeks before the election to deal with this matter. And that's going to be, they're going to have to do it really fast because there are going to have to be briefs written. There will have to be a hearing. The court will have to write its opinion. And again, all of that must be done in 17 days. So we don't know what's going to happen. To me, the opinion is tightly written. All it does is it looks at what the rule says, compares it with what Georgia law says, and if it was not consistent and in compliance with Georgia law, the Georgia Constitution, and the U.S. Constitution, the court said it is void and unenforceable. And he found those rules to be such. All right. So voter suppression did not work in Georgia, despite those 3 MAGA members. Here they are. Those 3 MAGA members, including one African-American woman. All right. Including one African-American woman trying to enforce voter suppression laws. But the judge said no. No. So again, we applaud the judge. Big applause to the judge. Huge applause to the judge. Thank you, the Honorable Thomas Cox. All right? So, I am Attorney Augustus Corbett, one half of the Defiant Lawyers, and each and every week we bring you at least one legal analysis of trending stories just like this involving politics, policies, personalities, or pop culture to empower you with the information you need to defy this unjust legal system and to nullify systemic racism. Until the next time, peace.